Reeves Immigration Law Group now brings you Immigration Law on Your Side.
Alright, magandang gabi po mga kababayan and welcome to another Immigration Law on Your Side dito po sa PHLV Radio. We come to you every Wednesday dito po sa PHLV Radio. Kuya Yo, galing po sa Las Vegas, galing po sa San Francisco, California. Kasama po natin si Attorney Flomy Diza. Nandito po kami, nagbibigay serbisyo publiko every Wednesday, 7 p.m. on PHLV Radio. Have you rocked the boat? Nako, well, maybe jumped off the boat, maybe, not literally, but itong tinatawag na jump ship, itong pag-uusapan natin ngayong gabi dito sa PHLV Radio. Mga kababayan, unlike students, tourists, and business visitors who enter the United States, while working aboard a ship or an airplane, they are generally prohibited from adjusting their status to permanent resident. This rule applies even if the crew member is attempting to adjust his or her status based on a marriage to a U.S. citizen. So kahit pala mag-asawa, mahirap pa rin. So with us tonight, nakikita niyo sa screen si Attorney Flomy Diza of Reeves Immigration Law Group from San Francisco, California, who will help us understand who these crewmen D1s are. D1, yun yung kanilang status mga kababayan, and explore the ways, the many ways probably that they can adjust their status while here in the US. Magandang gabi po sa iyo, Attorney.
Magandang gabi, Kuya Johan, at sa lahat ng viewers and listeners natin. Magandang gabi at maligayang Pasko na rin sa inyo dahil September na tayo. Ang bilis ng panahon, Kuya Johan, at ilang buwan na lang ay Pasko na. So, binabati na rin natin lahat mga kababayan natin, lalong-lalo na dyan sa Pilipinas na sila nag-umpisa. Sana siguro silang kakabit ng kanilang mga Christmas tree at Christmas lights, at sa mga mga malls ay siguradong may mga Christmas decorations na rin.
Nako, sigurado.
But anyway, yeah.
At meron na rin Christmas songs dito sa PHLV Radio, Attorney.
Yeah, that's good to know. Siguro yung lalong-lalo na yung kay Jose Marichan, malimit at palagi pinapatugtog ng radio, lalong-lalo na sa atin at dito sa PHLV na rin.
That's right.
Very good time yung ating pag-uusapan ngayon dahil marami sa mga kababayan natin, Kuya Johan, ay nasa crewman status, crewman visa sila, at nagtatanong sila kung paanong paraan na ma-legalize ang kanilang status. One of the strictest and more difficult ways to get a green card are people who came in as a crewman, obviously the visa or yung tatawag na nag-jump ship sila or hindi na sila umalis. So, sino ba ang mga crewman na to, Kuya Johan? So, it's really very important for us to define or understand what are crewmen. Kasi yung bungad mo kanina na ang mga crewman na nag-stay sa US ay they are prohibited under the Immigration and Nationality Act to adjust status. Nabanggit mo kanina na kahit mag-asawa sila ng US citizen or may mga anak na US citizen ay hindi sila makakapag-adjust ng status o makakuha ng green card through those petitions. So, intindihin natin, as you mentioned kanina, ang crewmen or crew member ay D1. They are non-immigrant visas or persons working on board commercial sea vessels or international airlines. So, hindi lang mga crew members, kundi mga flight attendants and pilots kasama dyan, Kuya Johan, providing services required for normal operations and intending to depart the United States on the same vessel or any other vessel within 29 days upon entry. So yun ang kanilang definition. They are coming here to work on board a commercial vessel or international airlines. Yun ang definition. So very important yan kasi may mga sitwasyon na nabibigyan sila ng C1D1, yung pala ang kanilang intention ay not to come here and work. So, as an immigration attorney, we find ways for them to adjust kasi ang argument natin is they are not really crewman. So, yun ang kanilang definition. Ang distinction, Kuya Johan, ng C1 and D1, right, yung D1 are crew members, ang C1 are transit. They're transiting into the US. Kaya, medyo nalilito minsan ang mga CBP officers at the port of entry and even USCIS officers kung ano talagang designation, because these two are they can be used interchangeably or they can be used at the same time. Kasi ang C1 pwede silang mag-adjust ng status. Ang C1 ho kasi is you're transiting through the United States and your final destination is another country.
Mhm.
For example, pupunta po kayo ng Guantanamo, to build, to construct a prison, right? Yun ang kontrata ninyo, and before you are able to, land sa Guantanamo, meron kayong stopover, halimbawa sa Los Angeles, and yun ang tinatawag ng C1, you are transiting, right? And then if you are able to come here under the C1 and they allow you to come here at hindi na kayo tumuloy sa Guantanamo, there's a possibility that you are able to adjust status if you marry a U.S. citizen.
Attorney, D1 at C1, you've already outlined the difference. Attorney, itong pagiging D, yung if you are, say for example, you're working for Philippine Airlines, flight attendant ka. Pagka ganun ba, attorney, is it the company who petitions for you?
Yes, the company should be like a sponsor, Kuya Johan, or rather your employer na sasabihin mo sino ang saan ka mag-work. So definitely you have to provide yung inyong employment contract with the airline company or shipping company. So part of the service ay yun ang ipaprovide po ninyo when you apply for a crewman visa.
Yan, okay. So nabanggit niyo na, attorney, na mag-a-apply. Paano po ba ang procedure ng pag-a-apply ng itong D1 visa? If say for example, you are a crew member of our flag carrier, paano po ba ang proseso nito, attorney?
Yes, ang take note mga kababayan, karamihan sa mga flight attendants natin and pilots, they usually hold more than one kind of visa. So wala tayo ganun naging problema na nag-job ship, di ba? Or nag-job plane ang mga pilots and flight attendants. Mostly ang nakikita natin are mga crew members, yung mga cooks, lifeguards, waiters, mga beautician, yung mga tagalinis ng kwarto, usually yung nakikita natin. Pero usually kasi ang mga pilots o yung mga employed ng airline companies, Kuya Johan, pwede sila rin mag-apply ng B2, B1, B2. Ito yung tourist visa application. So, most of the time, pwede gawin yun. So, like any non-immigrant visa, kagaya ng B1, B2 or student visa, ang D1, kailangan din po ninyo mag-apply online sa US Embassy where you are a resident. Of course, with the supporting documents, and you have to file the same form basically sa mga non-immigrant visa. Tinatawag natin DS, DS 160. You have to complete that online, right? And once you have completed that, and then you have to upload yung mga documents na kailangan, kagaya ng inyong photographs, yung mga employment contracts, part of the passport, etc. And then set an appointment with the embassy to get that interview. So doon mo makikita yung kanilang itatatak sa inyong visa at sasabihin sa iyo crew member C1 or D1 or C1/D1. Yun ang binibigay sa inyo. So once you get that interview appointment, you go in person like any other normal visa applicants are, in-person interview sa embassy, and once you get approved, then they'll give you either 5 years, right, as depende sa employment contract po ninyo, right, it's going to be a multiple C1, D1 visa.
Yes, actually, isa sana sa itatanong ko yun kung gaano kahaba kasi alam nga naman every year nag-a-apply kayo ng panibago if you were like working for our flag carrier, Philippine Airlines, for example, attorney. So, attorney, karamihan sa mga kababayan natin who are on this status, excited sila na especially when for example, ang flag carrier natin, yung kanilang anak, kanilang asawa ay pwede nilang maisama. Sometimes they have free tickets pa or something like this. Paano, attorney, yung mga dependents ng D1 holder, are they eligible to apply for a dependent visa?
Yes, Kuya Johan, kaya lang hindi kagaya ng ibang non-immigrant visa where you follow, di ba, yung letter ng inyong visa, like kagaya limbawa ng K1, yung fiancé, K2, di ba? Or
J1.
student visa is J1, J2, or F1 for student, and then F2 for dependents. Na wala pong D2 or D2 visa. So usually ang na-apply ng mga dependents that pertains to legal spouse and minor children, they should apply for B1, B2. Usually naman nabibigyan yan sila kasi as you mentioned kanina Kuya Johan, lalong-lalo na kung the flight attendants or pilots or even crew members who wants to bring their families sa kanila sa barko, and they're able to stay and dock dito sa limbawa San Francisco, then they can apply for a B1, which is a tourist visa, or B2 rather, tourist visa for pleasure ang kanilang applyan.
Attorney, right at the start of the program, we already gave them a tease about itong nag-jump ship, Attorney. What if, because is example dito sa California, for example, pagka pumunta sila, dumaong na sila sa California, parang ang sarap pumasyal, and probably they will find opportunities if they have relatives or something, and nag-jump ship sila. What happens to them, Attorney?
Marami sa mga kababayan natin na, they actually think about their future, right? Of course, as an immigration attorney, we don't advise them to violate the status. Normally, ang C1B1, they're only given 29 days, Kuya Johan. Lalong-lalo na kung sandali lang naman na nandito ang kanilang cruise ship, di ba? So especially now, ang San Francisco is hosting yung mga Princess Airlines and Carnival cruise ships, Princess Cruise and Carnival cruise ship that go to Mexico and yung iba naman sa Canada rather or Alaska, no? Minsan nga meron pa yata Hawaii, from Long Beach Island, dun ang kanilang port of entry. So mga kababayan natin, pag sila ay nag-stop over dito o dito ang kanilang start, usually they're given few days to rest, di ba? At bago sila lumabas, at pinapayagan sila actually to roam around and visit some relatives for a day or two, and the maximum of 29 days. So depende kung paalis na sila or something. So marami sa kanila, lalong-lalo na yung mga may mga kamag-anak dito that they made their own decision that they always stay. And as I mentioned kanina, one of the toughest way to legalize the status is a crewman visa. In fact, not only they are prohibited or banned from adjusting status even if they marry a U.S. citizen, they can also be apprehended and be sent back to the Philippines right away. Kasi yun ang kanilang isa sa mga what do you call this, the policy of immigration is they don't have that much right as a non-immigrant visa. Di ba? Halimbawa, tourist visa ka and you stayed here for more than 1 year na, some kind of may protection ka na. Di ba? You can actually ask them to see an immigration judge if they place them in removal proceedings. But in a situations for a crewman member, at pag sila nahuli, for example, diretso sila sa airlines, di ba? Sa airport, rather, at magkakaroon na ng para expedited removal kaagad, di ba? Kahit they've been stayed here, even if they stayed here in the US for a very long time. So isa sa mga disadvantage, Kuya Johan, ng mga overstayed na crewman. Unless, of course, they claim for what we call asylum. They say, I don't want to go home because something bad will happen to me and my family if I do, right? And if they claim an asylum, then they kind of like have a right to see an immigration judge. So basically, yun yung, one of the many disadvantages of an overstayed or jump ship crewman. But as we mentioned, Kuya Johan, there's always a way. As an immigration attorney, we advocate your case and find solution, di ba? Kasi kung andito ka na for a very long time, you could just imagine people come here, let's say, they've been here rather for more than 5 years, 10 years, 20 years yung iba. They have families and children. So even if they do have families, as we mentioned, hindi sila pwede mag-adjust. So no, we need to evaluate their case individually at titingnan natin kung paano paraan para sila maka-green card, di ba? So unlike in a tourist visa where nag-overstay sila kahit 10 taon pa yung overstay, right? They have a lawful entry, they have the I-94, they have the visa, then we can easily adjust the status. But not for a crewman. So we have to find out whether they are subject to 245I. Ano yung 245I na nabanggit natin then in our previous discussions, kasi ang mga 245I also applies not only for crewmen but people who overstayed and are adjusting status through employment base, or preference category. So crewmen that come under the protection of the INA 245I are not subject to the crewman bar. Right? So kung 245I kayo, kung sila po ay beneficiary ng petition filed on or before April 30, 2001, and they have to pay a penalty fee of $1,000. So yun yung penalty fee nila. But the qualifying petition may have been filed for the crewman's parent. Halimbawa sila ay minor noong 1980, for example, right? And they were 10 years old or below 21. As an F3, yung petition for a married person, alam natin that takes about 20 years. Kinamatayan halimbawa ng petitioner or even the principal beneficiary, so hindi sila nakakuha ng visa, or nag-age out na yung crewman, di ba? At that time, nag-age out na yung bata, siya na yung crewman ngayon. So he would be able to use that petition, underlying petition, to protect him from the bar. So yun yung 245I. So yun yung unang scenario, but a petition filed before April 30, 2001, Kuya Johan, they have also to prove that they were here on or after January 14, 1998. So kailangan pa rin ng physical presence requirement. But there's So yung una is petition filed before April 30, 2001, but they need to be in the US on or before December of 2000. So yung unang scenario. The other one would be yung 1998 petition, January 14, 1998. So yun, hindi mo kailangan ng physical presence. So kahit kararating mo lang dito, like kararating mo last year, at kayo nag-overstay, pero may petition ka before 98, petition po kayo o yung magulang ninyo, then you are able to adjust the status. So, and remember kababayan, itong 245I na to ay di panahon ni Bill Clinton, di ba, na sinabi niya dati na anyone who has a petition to be filed or will be filed on or before January 14, 1998, kahit overstay na sila as a crewman or as an employment-based or preference category, pwede pa rin silang mag-adjust provided they pay the penalty fee. And then, in-extend ni Bill Clinton yan kasi mag-expire yung petition, di ba, mag-expire rather yung law. So, in-extend niya yan. Sabi niya, okay, extend natin hanggang April 30 of 2001, but you have to prove physical presence. Di ba? Kasi marami na namang influx at that point na, mayroong bagong batas, so punta tayo ng Amerika para tayo, di ba? Mabigyan tayo. Kaya kinat nila yung batas na physical presence should be before December of 2000. So yung 245I eligibility ng crewman, Kuya Johan, that's really very helpful. And sa ating mga Pilipino, di ba? Marami tayong makamag-anak dito and hindi natin alam kung ang mga tita o tito ninyo, pinetition ang inyong magulang, right? O yung mga grandparents ninyo, pinetition ang magulang ninyo. You really have to ask them kasi kayo hindi nyo alam, baka naman 70s, 80s, up to 90s na wala kayong, akala ninyo hindi kayo kasama dahil nag-age out kayo, right? Pwede po ninyong gamitin yon. The 245I, Kuya Johan, is really a very effective tool to adjust status not only for crew members, as we mentioned, but also through employment-based na overstay or as also through preference category, right? Yung petitioning over 21 children. So that's one of the ways to find out whether kayo po ay makapwede mag-adjust. So hindi lang yung pag-aasawa ang pinoprotektahan ng 245I. So halimbawa, crew member po kayo at meron pong employer na gustong kayo petitionin as a teacher, as a caregiver, as a carpenter, right? Or as an engineer. So any of those employment petition, pwedeng initiate ninyo yon kasi kahit kayo po ay crew member o nag-jump ship, kung may 245I kayo, you'll be able to to get that green card when the time comes na maging available ang inyong visa. So, iyan po ang unang way para po kayo ay malegalize ang inyong status dito sa US by finding out whether you are covered under the 245I Immigration and Nationality Act law.
Attorney, kanina na-mention nyo kanina na yung ilan sa ating mga kababayan who are under this category normally will hold another type of visa. Usually, attorney, yung nila, crewman sila, and at the same time, are they tourists or are they, yung ibang status nila, attorney?
Yes, we mentioned kanina, pwede sila actually pumasok or mag-apply ng another type of visa, usually karamihan sa kanila, they hold another visa which is B1, B2, right? So that when they come here, instead of using the crewman because they are not joining a ship, they can also, since because they're earning that much money, pwede naman silang mamasyal, di ba? At mag-enjoy and probably bring their family on a B1, B2 visa. Now, there are situations, as we mentioned kanina, na ang ina-apply ng mga kababayan natin is B1, B2, right? And then ang ibigay sa kanya, misidentification as a crewman, binigay sa kanya C1, D1. Right? And then pumasok siya dito, tinatakan, binigyan siya ng 6 months. Right? So then, nakita doon na yung intent mo, what was your intention to come here to the US, is for pleasure, right? To visit places and relatives. Yung pala ang tinatak sa is C1, D1. So may mga kababayan natin na, nandito na yung visa, either they didn't really evaluate kung ano yung binigay sa kanila o nagmamadali sila pumasok at pinapasok naman sila, and then eventually they get married to a citizen, and then immigration would say, hey, you're a crewman, you cannot adjust because of this crewman bar. So you can argue that I never was a crewman, right? I was a businessman in the US. I was I was a chief executive officer of this company, right? And I never had any crewman training, right? Or crewman studies, di ba? Wala kang crewman book or seaman's book at wala kang intent to actually join a ship. So you can make that argument as long as there is no misrepresentation on your part, right? So yun ang pwede mong i-argue na I was a tourist visa and coming here a tourist, nakamali lang sila na pagtatak sa akin. And then pangalawa is very common, yung nabanggit natin kanina, Johan, where yung C1, D1, or kasi usually binibigay sa mga crewman member natin are C1, D1, no? Pero may mga C1 din lang na, as we mentioned kanina, na ang final destination nila is not the United States. They are just transiting the US, di ba? And under the law, they are not a crewman. They are just, kumbaga nag-stop over lang sila o layover sa US because their final destination is in another country like Cuba, for example, or Venezuela or other country na walang straight or direct flight from the Philippines to what do you call it, to Aruba or to Cuba, di ba? So nagkakaroon sila na binibigyan sila ng layover kasi halimbawa maghintay sila few hours or few days sa airport at as a C1 they are also able to enter the US, let's say for a few days, di ba? 5 days probably or 30 days, and then hinintay nila yung another connecting flight going to their final destination. In that situation, if they're not an actual crewman, but they are employees, right? Rather, who were tasked to go to another country, right? Hindi sila actual crewman, and if they marry a US citizen, pwede silang actually mag-adjust ng status. So those are very common, Kuya Johan, and we have seen many clients who came here kasi marami sa atin din, Kuya Johan, na worker ng Cuba, lalong-lalo na nagkaroon ng base sa Guantanamo, nag-establish sila yata ng prison for the 9/11 bombing ng New York, na, di ba? At saka maraming mga na-charge ng terrorists, and they were trying na doon ilalagay ng mga prisoners or mga suspects or those convicted, no? So nagkaroon ng maraming pangangailangan ng laborers and workers. So marami sa mga Pilipino na nabigyan ng C1 visa. And not only Guantanamo but also other countries, no, where they made the US as their stopover. Now in that situation, Kuya Johan, may mga kababayan natin na either papunta pa lang or pabalik, malabas na sila ng US and nag-overstay, and they find love in the US, and then we are able to evaluate the case and say that they are able to adjust. Now, the problem with some kababayan natin is when they apply for the green card, right, without consulting a lawyer, rather, or without having a lawyer at the interview, kasi ang immigration officer, wala rin masyado, minsan tinitignan lang yung yung status mo or yung visa mo, and they thought that you're a crewman, definitely, i-deny yung adjustment of status. So it's really important for you, mga kababayan, kung kayo po ay transit visa, right, to consult an attorney and discuss whether you are subject to the crewman bar or you are able to adjust status, right, kung kayo po ay may asawa ng US citizen or may anak po kayong US citizen.
Nako, all right. So mga kababayan, if you are in that situation, sabi nga po ni Attorney Diza, ay magandang kumonsulta para makita kung ano pa yung mga pupwedeng magawa at mangyari. Attorney, isa sa mga itinatanong ng ating mga kababayan, if say for example, ito naman usually pinag-uusapan natin itong mga nasa flights, mga nasa eroplano, itong mga kababayan nating mga nasa cruise ships, ang dami I'm sure you've been in cruise and mga cruise nakikita niyo ang daming mga Pilipino. Marami po bang mga kababayan natin na nasa ganitong sitwasyon na pagdaong sa Long Beach or sa San Diego ay sasabihin nilang ay dito na lang ako sa US, hindi na sila uuwi? Meron po bang mga kababayan tayong ganon?
Marami ang nagkukonsulta, Kuya Johan. Marami na rin nandito when they already establish a family and they come to us and say what are my options. But during the cruise ship that I had recently, Kuya Johan, like I would say 70 to 80% siguro mga Filipino, yung mga waiters, cooks, lahat yan, yung mga naglilinis ng kwarto mo are mostly are Filipinos. And of course, pag alam nilang immigration lawyer ka, they want to explore the options. And of course, sabi ko sa kanila, it's hard to really jump ship, lalo na kung may family kayo, right? At mga anak na maiiwan because it's not going to be easy for you to, to be overstaying as a crewman in the US. Either, ang advice ko sa kanila, try explore yung B1, B2 kasi mas may option sila, di ba? Pwedeng, if they plan to go to school or if they're professionals, teachers or engineers, pwede sila mag-petition as H1B. Kasi sa mga crewman, Kuya Yon, hindi pwede. Di ba? Hindi ka pwede mag-change ng non-immigrant status kasi very limited yung term na binibigay sa'yo. So either that, explore other non-immigrant visa, or kagaya ng student visa, or pwede ring student visa. Tourist visa or student visa or investor visa. So pwede nilang i-apply yun sa embassy at huwag nilang gagamitin ang kanilang crewman visa, if they explore some options in the US through other ways. So, pero marami, Kuya Johan, you can just imagine ang mga Filipinos, not only Filipinos but other nationalities as well na nag-jump ship, and it's going to be hard for them to explore options when they get married. So, yun yung dalawa na banggit natin na paraan, di ba, yung either we 245I sila or na-misclassified ang kanilang visa, and then may dalawa pa, right? Which is, unahin mo natin yung intent mo to come here is not really actually to work. So, yung pangatlo na pwede kayo mag-adjust, mga kababayan, is let's say, kumuha ka actually ng crewman, right? Visa, pero you only use that visa to enter the US. Kumbaga, wala kang intention to work. Marami sa mga kababayan natin, Kuya Johan, lalong-lalo ng mga fly-by-nights or mga agencies where, they promise heaven and earth for you to come to the US and, and work. Pero yung pala, hindi naman tourist visa ang in-apply sa inyo, kundi C1, D1, di ba? Kasi mas mabilis siguro, or I don't know, mas marami nakakakuha yan. Pero if you look at their history, Kuya Johan, ang kanilang education or work experience, wala naman silang training, right? Wala silang seaman's book, wala silang experience, although may ship siguro, wala silang intention to join the ship. So for example, ang kanilang destination is Florida dahil nandoon yung cruise ship, Royal Caribbean for example. So ang kanilang flights from Manila to San Francisco pa lang umalis na sila. So hindi na sila nag-join ng ship. So in that situation, there's also an argument where you can say that, look, I'm not an actual crewman, right? Although it was issued to me, I committed fraud and misrepresentation, but I'm now married to a citizen. So if that definition also holds true, and if you hire an attorney to make that argument, right, that you can file for the adjustment of status to marriage, and you should also be filing yung 601 waiver where you say that you committed fraud and misrepresentation, then that's going to be an option. But again, mga kababayan, this is for purposes of discussion only. A lot of cases are different in a way, so I would strongly suggest that you should consult an immigration attorney to fully discuss your case about this number 3 exceptions, how to legalize or adjust your status in the US.
some of the beneficiaries' attorney, as you mentioned a while ago, might have another petition, a family petition that they've been waiting for a long time. In the meantime, na hindi pa nandyan yung kanyang family petition, nag-flight attendant muna siya. No? So one of the things that deter people from applying for non-immigrant visas is pag nakita niya na meron akong immigrant petition, baka i-deny ako. Is that the case for this one, attorney? Kung meron kang pending immigrant petition from a parent?
Well, generally, Kuya Johan, when you apply for any kind of non-immigrant petition, kagaya ng B1, B2, crewman, or any of those non-immigrant visa, ang unang-unang tinitignan ng consular officer would be, whether you have a petition or not, right? You have a petition or not, you have family in the U.S., ang unang tinitignan ng consular officer would be, what are your ties, right, in the Philippines? Are you going to go back to the Philippines and resume what you're doing? Diba? So, whether you have a petition or not, I mean, it's a totality of your situation, whether the consular officer would give you that visa or not. So what I tell client is, let's say, gustong-gusto mo magkaroon ng tourist visa and meron kang petition, right? I would say na, okay, apply mo pa rin ang tourist visa mo despite you having a pending petition, naghintay ka na lang ng priority date, and see what the consular officer says. Right? As long as you are honest, number one, as long as you can establish your ties, right? Hindi ka nag-provide ng documents that, that are suspicious, that's number one, or that are fraudulent, right? Magaling sa recto or na madaling i-verify, right? Kasi it will come back to you later on, Kuya Johan, kung nag-provide ka ng document at nandiyan yung petition ng nanay mo, right? Instead of you na makakuha ng immigrant visa, madi-deny ka because of that fraud or misrepresentation. To answer your question is, I would strongly suggest, especially if you think you are eligible, is to apply for that non-immigrant petition and see what the consular officer says. As long as you document your ties in the Philippines, you're married, you have kids going to school, you have a business, right? And you have a stable job, right? Pero kung kayo po ay single, for example, tapos registered nurse pa kayo sa atin, may petition pa kayo, anong option mo? Pwede ba akong mag-apply? I would say, yes, try mo pa rin, right? Sabihin mo ang mother mo mag-employ sa'yo kung wala kang pera, di ba? Huwag ka lang mag-provide again or magsisinungaling na, pag tinanong nandun ba ang parents mo, petition ka ba? Baka sabihin mo hindi. Syempre, in the future, lahat yan, would come up at the time of your immigrant visa interviews.
Yes, all right. Okay, kaya mangyari mga kaibigan na kumonsulta, if you're there in the Philippines, ang mga kaibigan natin from Reeves Immigration Law Group, they have an office there in Makati. Attorney, ma-invite natin ang ating mga tagapakinig at tagapanood sa ating mga offices na kumonsulta po sa Reeves Immigration Law Group.
Yes, Kuya Johan, ang Reeves Immigration Law Group, several offices. We are now accepting in-person consultation. Marami na tayong mga kababayan that go into our office in San Francisco. You can see our telephone number there. We are located at 425 California Street. Malapit po sa mga public transportation ito and parking are accessible. Right? We can also do Zoom or phone consultation. Same thing with our office in Los Angeles area. And then also Makati and China and elsewhere in the world, you can do a Zoom consultation. Just contact us at our website. Now, before probably, Kuya Johan, yung isa pang paraan para maka-adjust ng status ng mga kababayan natin o makakuha ng papel, yung mga crewman, di ba? 245I, misclassification of kanilang visa and then misrepresentation of the intention. And then yung pangatlo is very common, Kuya Johan, is yung 601A. 601A waiver. Kung hindi sila 245I, right, wala ring fraud or wala ring tama naman ang visa nila, talaga silang nag-jump ship pero wala silang ibang kamag-anak na nag-petition sa magulang nila o sa kanila. So ngayon meron na silang asawa, may pamilya na sila. How can they apply or legalize the status? Kasi kung uuwi naman sila, Kuya Johan, they're subject to 10-year bar, di ba? Maghintay sila sa Pilipinas ng bar and they can also apply for the 10-year bar waiver, but the processing time will also take about 2 to 3 years. So especially if you're taking care of an ailing mom or a spouse, right? And you are the principal, financial principal provider sa pamilya ninyo, ang hirap mawala ng 4 to 5 years. So ito yung 601A that President Obama also initiated right during his term, where sabi niya kung nag-overstay kayo, right, at kayo may pamilya na kayo dito, right, you have to apply for that petition now here, nasa Amerika pa kayo, and then once it's approved, you file the waiver, 601A. Kaya tinawag na A yan, Kuya Johan, because you cannot adjust status in the US. You are kind of provisionally asking forgiveness sa USCIS na, di ba? Para mapatawad yung 10-year bar mo. Mm-hmm. So before you depart, right, you file that provisional waiver saying that your spouse would suffer extreme hardship. So for example, na-approve yon, then continues yung process sa National Visa Center, and then schedule ka ng interview sa embassy sa Manila. And dun ka lang uuwi, di ba? Once you receive that interview appointment, and then for you to do your medical exam at St. Luke's and go to the interview. During Obama's time, marami tayong mga cases, successful cases na na-approve, Kuya Johan, and ang kanilang stay sa Pilipinas lang ay mga 3 weeks. 3 weeks, yung pinakamabilis, ang pinakamatagal is 3 months. Halimbawa, nagkaroon ng problema sa medical, so kailangan nila ng sputum test, etc., or may konting administrative delay, which is still very good kasi 3 months para ka lang nagbakasyon, di ba? Yeah. Lalo na kung, 10 years ka nang, nag-overstay sa Amerika. So, yung client namin at that point, 3 months ang waiting, 3 weeks lang, minsan nakakabalik na sila, uuwi lang sila for the medical, and then once they go to the interview, na-i-issue yung kanilang visa. Now, ngayon, mabagal ang 601A approval. Ang processing time nila is 3 years, which is still okay kasi nandito naman kayo sa Amerika, di ba? Kahit maghintay ka ng approval ng 601A mo, right? Yung uwi ka pa rin lang by the time na magkaroon ka ng interview. Mm-hmm. So ito ay very effective tool din, Kuya Johan, lalong-lalo na sa mga kababayan natin na may mga asawa, right? May mga anak and or may mga magulang that we are who would suffer extreme hardship kung hindi ma-approve ang kanilang provisional waiver. So that's the fourth way for them to legalize their status in the US. And I know there are many ways for them to adjust, find time to consult an immigration attorney. And by the way, idagdag ko na rin, Kuya Johan, yung panglima pala is yung if they are a victim of crime. Like for example, they witness a crime, right? Like for example, robbery, tinutukan sila ng baril, halimbawa, o binugbog sila, huwag naman sana. Pero if that's the situation and you reported that incident to the police, even if you're a crewman, there's a possible way for you to legalize your status in the US.
Ayan, okay. Mga kababayan, 5 ways for our friends and kababayans na mga crewmen under D1 or the combination C1D na visa na makapag-adjust while they are here in the United States. Attorney, maraming salamat. Maganda itong napag-usapan natin at I'm sure marami tayong because sometimes, like for example, lang nung last na pinag-usapan natin, iniisip natin, ano kaya mga visa ng mga pare? Ngayon, alam na natin kung anong mga visa ng mga flight attendant na nakikilala natin sa papunta dito. So, very, very, very informational. Maraming salamat, Attorney. At this point, I'll give you this time to address our audience, Attorney. Baka meron po kayong mga ibang takeaways para sa kanila.
Well, unang-una ko yan, maraming salamat ulit sa patuloy ninyong pag-suporta at public service natin. 5 years na tayo, Kuya. Nag-show ako sa aking Facebook recently. 5 years, that's the first interview natin, parang kailan lang,
parang
diba?
Kailan lang, no?
Pinag-usapan natin, master's degree ng 2 years. Ngayon, 4 years, parang master's degree, doctor degree na tayo. 5 years na. Right, maging CEO na sa isang, company because of the length of time. But, this long service natin, and bihira nating na-miss ang twice a month nating discussions on immigration law. This always very interesting topic, kung hindi updates, discussions about a certain kind of visa sa United States, and there are many ways for you to find what's the available visa for you, or if you're here already, especially if you are still out of status, you have our phone number. And contact us. We have a consultation fee of $100, but we can also waive that, especially if you mention PHLV Radio. Maraming salamat ulit, Kuya Johan, and I'll see you in person next time.
Nako, maraming salamat, attorney, and on behalf of the Filipino-American community dito sa Las Vegas and ganun pa man dito sa buong United States, maraming salamat po sa inyo, and ang Philam community, especially dito kung nasaan ang PHLV Radio sa Las Vegas, really appreciate the information and the public service that we're rendering through the support of Reeves Immigration Law Group. Maraming salamat po. Okay mga kababayan, hanggang dito na lamang po ang episode natin ngayon. Sa susunod ulit, as you've heard, magkasama kami ni Attorney Diza dito po sa PHLV Radio Studio dito sa Las Vegas. Nako, sana wala ng ulan, sana wala ng baha sa Las Vegas. Pero we survived it and we're okay mga kababayan. At sa mga kababayan natin sa California at sa buong Amerika at sa buong mundo, maraming salamat po. This is Kuya Yo from Las Vegas, and we will see you next time.
Reeves Immigration Law Group has been representing immigrants for nearly 40 years. Reeves Immigration Law Group has been fighting for its clients through experience and expertise. With immigration lawyers you can access at reasonable fees, even on Saturday. Payment plans are also available. Call us for your immigration solutions. We can do worldwide telephone and Skype consultations. Reeves Immigration Law Group, 1-800-795-8009. Reeves Immigration Law Group has offices in Los Angeles, San Francisco, China, and Philippines. See us at www.rreeves.com. Reeves Immigration Law Group, 1-800-795-8009.
Reeves Immigration Law Group has just brought Immigration Law on Your Side. Wednesdays, 7 p.m. Pacific on PHLV Radio.